Before I get into that, I'd just like, for those of you who are not familiar, I'd like to tell you a little bit about Legal Fee Advisors. It's a consulting company that I created a number of years ago. The concept of Legal Fee Advisors is to move beyond e-billing concepts and to create efficiency with respect to the utilization of lawyers if an hourly billing basis is used. What that means, utilization coming down to the right number of lawyers, the right lawyer or staff member for the task at hand. The other concept is we believe that in-house time can be much saved if the process is efficient. We also believe that there are specific areas for savings that go far beyond rate. We'll talk about that too. And part of our experience is doing forensic and expert work on behalf of corporations when there are billing issues. So that having been said, what I'd like to do now is I'd like to move ahead and talk a little bit about what we're going to be doing today. First of all, I'm going to be talking about what I believe to be a disconnect between clients and their firms in the instance of hourly billing. I'm not going to address alternative fee arrangements today. That's its own subject, as many of you know. And I'm going to be talking very clearly, I hope, about those situations where clients and their firms just are not communicating. That being said, I'd like to talk about issues and solutions, and I'm going to talk about 6 of the most frequently mentioned billing issues and some solutions that we think can really help. At the end of the program, I'm going to be talking about further points for consideration, and for the benefit of all of you, we'll be making this program available if you'd like to share it. And if you would like any more information, obviously, we would very much like to hear from you. We believe that we will be finished with the presentation somewhere approximately 2:45 Eastern Time. If you have questions, please send the questions in on the chat feature, and I'll do my best to address them. I will be pausing at different points if anyone would like to participate, but that's basically where we're going today. Here is a concept that is very much of a pet concept for me and the people who we work with. This concept has to do with something a little different. Many people in the legal billing area, I believe, become very polarized because they see it as a difficult process. They see it as a process where firms are being scrutinized against what their clients need or wish, and I do not believe that that's reasonable. I believe that there is the potential here for many, many wins. So, for example, I believe that the value analysis is incredibly important. What this means is, what is the value of a given transaction to the client or the corporation? How do they feel about it? Are they getting the right product at the right time in the right way for the money that they spent? So this value analysis then has to be weighed against an efficiency analysis. I use the word efficiency rather than compliance because I believe efficiency is not the same as compliance. Efficiency means that the right number of lawyers are doing the work. It believes that the lawyers are working quickly. It means that you have the right person doing the right thing. And we're going to get more into that toward the end. And then beyond efficiency is transparency. What I mean by that is, can a reasonable client reading the bill completely understand what it is the lawyers and the staff are doing? It may or may not surprise some of the people on the call that we do a great deal of work on a forensic basis and an expert basis, and we see really, really sloppy work being done by some law firms in the way they record their time. I want to be very clear. There are many law firms that do a spectacularly good job at all of these things, and I don't think they're talked about enough. The last element is consistent monitoring and cooperation is compliance. It's very disheartening for a law firm that's trying really hard to hear about other law firms that are not carrying the ball and complying with billing standards, but yet they get paid just as well. That's really not a great feeling. If you take the value analysis, if you take the efficiency analysis with reasonable monitoring, and you put them together, what you get is lean, transparent, efficient legal spend. Now, there are companies that have done this extremely well. They are models, they are fantastic, but there really are not that many of them. That means that what we would like to do is find more companies that do it, help others do it, and move the ball along. Let me talk about the disconnect. Here's what I mean by that. And many of you have heard this, so I don't have to go into it in great detail. Some law firms, their economic model demands what some might see as inefficiency. Too many lawyers doing too many things at the same time when one lawyer or two lawyers might be able to accomplish it. That's improper utilization. I have seen so many attorneys, and I experienced this for myself. When I was a chief operating officer for a company and a general counsel, reading a bill, saying to myself, why are there so many lawyers doing these things? We don't need them. I thought these people were good at this. Obviously, there are other firms that are incredibly efficient. So that economic model for some law firms is an issue. The other thing is the concentration on rate. Now, here's what I mean by that. There are many law firms, and to me, improperly, many companies that are so concentrated on rate and rate analysis that they leave out the most important part of the equation, which is the rate is meaningless if you have too many people multiplying that rate per task. So, for example, when I was a chief operating officer, I remember I used an employment firm where I could call up the partner, who was a great guy, and I could ask him a question, and he could give me a good answer in about 10 or 15 minutes. Contrast that with the situation with another firm where they would not have that inherent knowledge, and you might get 2 or 3 lawyers with research memoranda and so on. I think you understand. Rate for the second law firm was really not a great indication of what the total cost would be of the opinion that I was seeking. I believe that you need to talk about both. What is the rate and how efficient is the firm? Here's another problem. I've seen many companies that have unclear billing guidelines and inconsistent compliance. Billing guidelines that are not clear are a problem. Let me explain. For the firms that have great billing judgment, they probably would give you fair bills even if you had no billing guidelines. Then there were the firms that really need some great guidelines and they need a nudge every once in a while. And then there were the firms that are always having a problem at the other end of the spectrum. Therefore, that's the issue that I think is really an important one to emphasize beyond the other two. Here's the first issue I'd like to discuss. The question goes back to utilization. Why are there so many staff on this matter? Does the matter require all of these individuals? Rate versus utilization is the issue. As I said before, there is a need in many companies to focus on this, especially in litigated matters, and especially on matters that are unique. So unique transactions, emergency transactions, litigation of various kinds, where it is you have a more fluid matter. The other is, and this is something that I think is an important point to make, many in-house counsel just are hesitant to interfere with staffing. They feel that it is not their place. And by the end of the day, you end up in a problem. The total cost can really escalate, and budgetary control can drift. And by the time you get around to talking about it, you could be way down the road. So let's look at 2 case studies for a second. This first one was the result of a forensic study that we did on behalf of a manufacturer earlier this year. There were 122 timekeepers on this case. There was $38 million in fees. This was one case. 10% of the billing, at $3.8 million, was only on document review. and the document review is being done in-house. There was even an attorney who was charging for reading team emails at an exorbitantly high rate. What can we say about this case? It was out of control. The in-house counsel who was involved felt overwhelmed by the case, did not want to interfere, and then it fell to an in-house counsel down the road to actually try and deal with it. There was also a case like this that I experienced where an insurance company had reserved rights and then later came in and had the terrible job of having to find a way to justify paying highly inflated fees in a conflict case. So for those of you with insurance background, you'll know what I'm talking about. Second case study. In this case, very similar to the one I was talking about, there was a call that was arranged with the firm's tax specialist, but when the in-house counsel dialed in, there were 2 more attorneys on the call. She later received the bill for all the time chargers, and incidentally, when that in-house counsel received that bill, that's when she called our company and we began to work with her on how to avoid this. Here are some potential solutions. Some preset staffing models in budgets and clear billing guidelines that control staffing patterns can really make a difference. The other is just disallowance of charges that go beyond a core group. The whole core group concept is something that I'd be happy to get into with any of you, but it really does work. It really helps, combined with budgeting, can really have an effect on utilization. Again, please feel free for any of you who wish to ask a question or to pose a question, please use the chat function. And for those of you who have not dialed in, so a couple of people still have not dialed in. We're making sure everybody knows. Okay, next issue. Here's another question, and this happens with some law firms. On an overqualified for task element, some portion of low-level tasks are sometimes performed by attorneys at a higher rate. These levels of efficiency can fluctuate. During the time period from approximately 2008 to 2009, when we were looking at bills during that period, one of the things that we would see is there were lawyers who were literally running out of reasonable tasks. During that time period, they were performing low-level tasks at high rates, basically because they didn't have more to do. Sometimes lawyers are impatient. They want to do something themselves. They don't want to deal with a paralegal. The problem with that is that it really impacts upon the client, and this other element of utilization can have a very big impact. Paralegals performing clerical level tasks. Let me talk about this one for just a moment. Many people who are out there charging time right now are ignorant of a very basic idea. The American Bar Association has set out rules for paralegal certification, and in doing so, they've really studied the subject of paralegals. Paralegals are not and should not, according to the ABA, be a substitute for purely clerical or secretarial work. They should be charging for some sort of professional skill and actually should be saving the client money. When a paralegal performs tasks that are primarily secretarial tasks, all that is shifting overhead back over into the bill where it shouldn't be. When we do diagnostic analysis for some companies, this is one of the things that we find that can really make a big difference going down the road. Fortunately, with reasonable physical monitoring, this type of thing can be picked up. Unfortunately, just using e-billing systems generally does not pick up this element. Here are a few examples of this sort of thing. An associate charging $350 an hour, charging for data input on a document database. We see this many more times than you would want to believe. So one of the pieces of advice for you out there who are in-house is this. You might want to be very careful about in-house people performing document discovery elements or e-discovery, because this is the sort of thing you can start to see. Paralegals charging at high rates for copying and scanning, or for traveling to court to file a form document. This is less so in some areas, more in other areas. These are all things to look for. The billing guidelines with examples clarifying the tasks, this is an important point. Consistent and fair physical monitoring of billings to reinforce the guidelines, also important. What I'm pointing out here are types of charges that are not as easily caught by e-billing platforms. They generally don't have an ability to do this type of adjudication on a consistent basis. Here's another one, paying for staff training and bringing lawyers up to speed. So staff training, let's talk about this one. This happens in some circumstances more than one would think, where staff, especially on a large case, are essentially learning internal software, many times e-discovery software, but another version is when new attorneys learn their field at the client's expense. There are a number of clients who we work with, for example, that do not believe they should be paying for first-year associates at all. To them, the first-year associate, and I remember what it was like when I was a first-year associate, there were paralegals in the firm I worked with that probably knew a whole lot more than I did. So that whole element of not paying for training, it's an important point. It can make differences in terms of the total cost of your matters. For those of you on the law firm side, this is something to think about as well. When you've got that summer associate, the first-year associate, or law clerk, and they are charging time that might not be as reasonable down the road. Bringing new staff up to speed. This is a real problem on lengthy engagements, primarily litigations. It is common for new staff to be substituted, but what should be exercised in billing judgment, if the firm is doing their job, is not to charge the client for the up-to-speed time. In some of the files that we have seen, this has been an element that has been really right up there front and center. And for those of you who are not watching for it, this is something to watch for. So here's a few case study ideas. If a firm is gearing up to manage large document production, charging the client for internal training, bringing in temp attorneys and contract attorneys, incidentally, and this is just something to think about, there can be serious ethical issues for charging contract attorneys on a for-profit basis. And that's something to really think about. Now, let me say that one more time a different way. If a firm does not have the people to accomplish a very quick and complicated document task of thousands or even hundreds of thousands or millions of pages, what some firms will do is bring in contract attorneys. At that point, there is a division on ethical rules as to how and when the client may be charged. This is, again, its own subject, but I think those of you who are thinking about that now are thinking about the following. Is the contract attorney just a disbursement like an expert, or is it permissible to bring the contract attorney in and then charge a profit for that? The next element is when the firm changes a lead partner in complex litigation. This actually happened in one of the cases I was involved in, where the lead partner changed 3 times in 3 years. Every single time, it became a significant additional expense. So that's the element of training and up to speed. Again, if anyone has any questions, would like to talk about anything we're doing, please do me a favor and type in a chat question and we will address it. Travel. This is one of those areas that really depends very much upon the kinds of matters that are being handled, local, out-of-town combinations. If there is not a clear rule in this area, or there are too many exceptions in this area, travel can really add up. For those of you who have matters or have practiced in towns like Los Angeles, New York, Washington, D.C., Chicago. There can be times when your counsel are traveling more than they're actually in court or at a meeting. In those circumstances, you need a clear rule, and you need a good way of administering that rule. One of the things that I'm also going to say is that you need a way to develop exceptions to the rule in exceptional circumstances. Good guidelines are flexible, and they have ways of implementing exceptions without hollowing out and abandoning the rule. Out-of-town travel, there are a number of approaches to this taken by different companies. For some companies, they'll say, if you're doing substantive work while you're traveling, charge us for that, but we're not going to pay you to have dinner and watch a movie on an airplane. Others believe that there is an opportunity cost on the attorney's time when they're doing out-of-town work, and they can be charged at a half rate or some other discounted rate. And others will pay full rate under some circumstances. I believe that there is no perfect and correct answer to this. I do believe it is important to think it through. Here is one of the areas that we have seen before. Travel charges for driving to a local court blended into a block bill charge. I'm going to stop there for just a minute. And here's really something to think about here. For those of you who are either creating bills that are a block bill basis or see bills on a block bill basis, the distortion that travel makes is fairly significant. So here you have one where the travel time was 4 hours, the entire time was 4 hours long, but the court appearance was half hour. If it is a block billed entry, it's impossible to figure out which part of it was substantive work and which was not. In that circumstance, the travel time should have its own rule and should not be blocked in so that it can be adjudicated properly. Here's another one. If the counsel charging at full rate for 8 hours of travel with 1 hour of preparation and a 1 hour meeting, this is a judgment call by the client. But what I'm emphasizing here is that travel should be something that is addressed, something that's talked about, and something that's fair. One of the least fair ways that this can be done is to have no rule or no good rule. And what happens is different firms get treated different ways. That's not great for fairness, and it's not great for morale. Here's another issue. Some disbursements, and this goes all over the map, some firms charge disbursements that really are firm overhead. Others charge matter-specific disbursements, and the line between a true matter disbursement and recurring overhead is not always clear to the people in the law firm. Let me explain. Most people who think about this issue, and incidentally, the American Bar Association has very specific opinions and rules on this subject. And here's what it really comes down to. Any cost that is an ongoing cost, meaning it is not matter specific, those elements, those costs should definitely be dealt with by the firm without passing on to the client unless there is a specific and clear permission to do so. So I'll be going through a couple of examples in the next slide, but one of the issues here is situations where the firm is truly pushing through things like conference room costs, heating and air conditioning, and other things that are just, in most people's point of view, should never be paid. There was one client we worked with that was getting so much of this from certain law firms that when we actually were adjudicating their bills, we cut out 85% of these types of disbursements in the first 6 months. That was a very big number to them. Here is the deal with this one. This is one of the easier ones to make decisions on, especially if one considers what are really best practices in this area. There's been a lot of work done on disbursements. There's been a lot of work done with e-billing systems, keeping track of disbursements. For those of you on the law firm side, if you want to be a hero to your clients, try really to pay attention to this one, because this is one that really bothers people. So disbursements, overhead, push-throughs that do not look reasonable or fair, big item. So here's a couple of issues, especially on larger matters and especially on law firms that are used to charging this way. There are times when everything from word processing to overtime staffing, staff meals, so many things, all add anywhere from 5 to 10% to billings on a regular basis. What we do for many companies is we do a diagnostic analysis of their bills, and we look for the types of things that are slipping through. And many times it really does add up to a fairly significant amount of money. Some solutions. Clear billing guidelines on this is just a must. But more than the clear billing guidelines is really consistent monitoring for compliance. If that is not so, these charges slip through, they're not enforced, the law firms believe that it's fine, these things will just slip through, and unfortunately some law firms take advantage of this while others do not. As I'm going through this, I do want to emphasize something. Most law firms actually are great with their clients. There are those few, though, that are not. Unfortunately, a lot of these rules were created to avoid the issues with those law firms that do not do this very well. Another issue, legal research. We have seen files where up to 10% of the amount that is billed on a litigation is research. The elements of research and the thoughts about research and paying for research have a wide range in the clients that we've been around. Some firms will allow junior staff discretion to perform lengthy research. It's really a training tool. And those of us who have been in those situations know it when we see it. Such practices, they really do hurt the credibility of justifiable research, and that really hurts the credibility of the firms. I had one employment counsel who I worked with who said to me point blank, I hire one of the best employment firms in the country. If they don't understand this type of thing, then they shouldn't be working for me. I'm not paying for their research at all. Others will very easily pay for it and have no problem with it at certain levels. Online subscription pass-through. Here's one that can be a real problem. The way that some online databases work, there are charges that are created in the database that are pushed through into the billing platform that are not equivalent to a pro rata charge on the monthly charge. Now, let me put that a different way. Let's take a law firm that is paying on a monthly charge X amount of money. They're paying for their database. They will use that database a lot, a little. They're going to pay the same amount of money. In fact, the firm would pay the same amount of money even if that law firm was not working for that client. Therefore, one could say, isn't that monthly charge really a part of firm overhead? Putting that aside for a minute, let's say a research trail is created and research is done on behalf of the client and a charge is created. Is that charge the actual amount that the firm pays? Or could it be more in some circumstances? I am asking all of you to really think about this. There are obviously a lot of issues with this. And this subject is one that some companies have dealt with by just saying, we're not paying for online research at all. At all. Others put a limit on it. And so there are many ways of dealing with it. I know I'm covering a lot today, but this is one that really bothers some people. What many people do when they start reading bills is they start reading the bill the same for every kind of problem. So if you see a postage charge that's out of whack, you look at it the same way as whether or not there are 3 or 4 or 5 or 6 lawyers working on something. This was created for one of our clients who requested it, and here's the issue. If you look at this axis here, the fee reduction per task goes up. So eliminating time increments of 0.25, that really creates a lot of savings. Eliminating clerical tasks by professionals creates a lot of savings. How hard is it to administer the rule? Well, if you move in this direction, you need more and more attention, more and more physical monitoring, and more work to administer that billing rule. So essentially, if you're looking at the graph somewhere around here, this is the area where you can really start to see the most changes, and of course this one might be worth it for you, if you put the time and the effort in. Now, these percentage savings are not cumulative, they don't stack. But if you put them together, you start to see these types of savings created over time. Again, the fee reduction per task going up, the complexity of administration going in this direction. Okay, let me talk about something else. Despite the issues that we've discussed, many companies' billing guidelines are very hard to work with. And some of them are so long that they're very difficult to work with. They're just page upon page upon page. Others have billing guidelines that are short, which is great, except they're so vague, it's hard to know when there's a problem. My feeling, focus on reasonableness and effectiveness. Focus on the core elements that will give you the most bang for the buck. That's where I think people should be when they're talking about billing guidelines. The other is to focus on standards that create real efficiency, real tangible savings. Another element, transparency. It is actually surprising to me the way some firms resist billing clearly. And I have actually seen companies that are reluctant to make them bill clearly. What billing clearly means is you don't want one or two words in a time charge, work on matter, something like that. It's impossible for a client to really understand it. And that's really an unfair situation. The next is the standards should be such that if someone's reading the bill, they know when there's a problem, they know when there's not a problem, and benefit from industry best practices and cooperation. There are such great best practices out there for billing guidelines, for monitoring and monitoring workflows. It will save you a lot of time to get access to them. And we can help with that, and there are other places you can go as well. Here are a few conclusions that I want to just get out there on the table. One is, I think clarity is, and fairness in general, is something that all of us need to strive for. Clarity means you want billing guidelines that people agree upon. You want billing guidelines that get the most economic elements, and you want to make sure that those elements are really having an impact. And better communication by having clarity helps as well. Flexibility and fairness. Once the billing guidelines are set, you want to make sure they're fair, you want to make sure they're flexible, and I really believe that bringing law firms into the process of amending and creating the guidelines makes them better. And I'm not sure many other people do this kind of thing, but having spent a lot of my life in law firms, I think it's important. Efficiency. Remember that rate negotiation is just the beginning. And incidentally, the partner's rate is just the beginning. If we look at some of the studies that we have done, we have seen that there's actually more total cost in associate and paralegal time than there is in partner time. Concentrate on those lower rates for those other positions. That's where you'll see a lot more of what you need to see to determine how much you're really going to pay at the end. Utilization, extremely important. We talked about that one before too. Consistency, incredibly important in this scenario. I've seen so many companies that have billing guidelines that are not enforced, monitoring that no one has time for. These elements and these issues have to be addressed. They actually hurt law firms who try to be compliant and then find that no one's watching. That's not good for them either. So for everyone's sake, it's great to have great guidelines, reasonable workflows that help everyone do this quickly. In fact, we find that with the right workflows, that quick pay discounts actually work pretty well for companies, and that's good news for everyone. I want to thank everyone who's been on the call. We are ending about 5 minutes early. Do we have any questions here? Okay, I'm seeing one question, several questions. One is issue, I have seen significant charges for pure travel. Is that reasonable? It's not reasonable if there has been a clear prohibition against pure travel in the past. In other words, you need to have some clarity on your guidelines. Another person has said, I have been charged for work that does not appear to be complex or justified by the rate. That's a real issue. And I can tell you that if you have the right guidelines in place and the right monitoring protocols, that kind of thing will get caught. There are ways to do that. Okay, do we have any other questions? Someone else has been talking about staff training, which I believe we've all talked about a lot. Some of the disbursements on the bills appear to be firm overhead. Should we be paying those costs? And the answer is no. There are actually elements of some of the some ethical rules that can be applied in that situation as well. Finally, legal research seems to be performed on a repetitive basis. Here is something I really want people to think about on the call. If your company pays for legal research once, why should you pay for it again? You shouldn't. The reuse of the legal research and the knowledge and the familiarity with your company should be to your benefit. You shouldn't be paying for it over and over and over again. Another issue is paying for online subscriptions. There are many people who feel the following. When I first started to practice law, and some of you will know how old this makes me, we had no online subscriptions, we just had books. And would we ever have thought, under any circumstances, of charging our clients for our subscriptions to those books? And the answer is absolutely not. Those were the tools of the trade. Yet a lot of many law firms today think nothing of charging for online legal research subscriptions. They're basically, in my opinion, pushing a tool of the trade, their overhead, back and making their clients pay for it. I'm not saying that it is wrong to the point of being actionable or anything at that level, but it is certainly an issue. And good questions, and I do appreciate them. If anyone else has more questions, please be sure to send them through. For all of the rest of you, thank you so much for attending today. Talk to you later. Bye-bye.